Hey, good freaking morning, everybody. It's gonna be a very different video. Now, we're gonna go over something, and I haven't made military history or content in a while, so I feel like I found an appropriate time to go over this download content. Let's go. Let's talk about Title 10, UCMJ, and the freaking UCMJ and Command Authority. Let's make a very big disclaimer. This summary is for informational and educational purposes only. It does not reflect the official views of the United States Marine Corps or the Department of the DoD, Department of Defense. This guide does not constitute legal advice. Let's go into Title 10, the foundation. Military law. Title 10 of the U.S. Section Code is the bedrock. It provides legal basis for the existence of the DoD and defines how command is exercised. The COC, the chain of command, divided into operational, for combat, and administrative, for training and equipping. Operational chain, presidents, the SOD, combat commanders, Secretary of Defense, down from there. Operational chain, as you see, I say again. The administrative admin chain now too is the President, Secretary of Defense, Secretary of the Navy, Commandant in the Marine Corps for the UCMJ, no, for the UCMC. Now let's talk about NJP, or Non-Judicial Punishment, Article 15. Under U.S. Section Code Section 815, commanders have the authority to handle minor offenses without a formal court-martial. In the Marine Corps, it's also known as office hours, the power of rank. Who can give what? Is the interrogative authority determined by billet, position, and the rank of the officer, OIC, officer in charge. Authority level, imposing officer, max restrictions and max forfeit, max reduction in rank, and listed. Let's get started. Authority level, company grade, captain, 03 in the Marine Corps. Maximum restriction, 14 days, maximum forfeit, 7 days pay, maximum reduction in rank. Enlisted, 1 grade, E4 and below. Field grade, LC, Lieutenant Colonel, 06, 05 through 06. 60 days, the maximum restriction. A half month of pay, or 2 months max. And E1 to E1 to E4 and below. 1 grade for E5 and E6. So basically, Staff Sergeant and Sergeant, so NCO to Staff NCO. And obviously, Junior Enlisted Marines to E1 to E4. Like your private first class, and Corporal and Corporal. Corporal obviously an NCO too. Let us continue. General Officer, Generals 07 plus 60 days, maximum restriction, 1 month's pay for over 2 months, maximum forfeit pay, max rank, max reduction rank, same as field grade officers, Lieutenant Colonel 03 06. Your legal rights at office hours. Marines are often surprised by their rights to retrain during NJP. You have a right to refuse. You can turn down an NJP and a court-martial unless you are attached or marked on a vessel. You have the right of silence. Article 31 UCMJ, you don't have the right to see anything that incriminates you. You have a right to a spokesperson. You can have someone who speak for you, not through typically a jaguar during the hearing itself. Basically saying during the due process part of the actual NJP or court-martial per se. Now, let's go back. Let's play a different game. New game. Engine. Let's do do unlimited time. Let's do depth of 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 20. Okay. Now let's just get started and continue. This is going to just be simply background showing. What's it called? Stockfish is black, Komodo is white. The legal vocabulary you must understand. If you want to understand the basis of this, you have to understand the precise terms. The correspondence of the evidence is a standard proof of UCMJ, 51% certainty to be exact. This is much lower than beyond a reasonable doubt required for court-martial, 99%. Exoneration and mitigation. Matters presented to explain why something happened or why the punishment should be lighter. Basically saying, for another term, and a vessel exemption. The specific clause in Title 10 that prevents Marines at seas from refusing NJPs on a vessel. Key takeaway from this: Cattle use this section code ensure that discipline is swift but regulated. All commander has to give from office without authority. That authority is strictly capped by rank and Marines ranks. The decision to accept NJP is not a tactical choice. You avoid a federal criminal record, but you accept the lower burden of proof. Now, let's go and do a strategy. Disclaimer: this analysis for educational purposes only does not constitute legal advice. It not represent the views of the Marine Corps, Department of Defense, Marines facing NJP should counsel with defense counsel, and legal support center. Let's talk about burden of proof and conflicts. The strategy hinges upon a difference between two legal standards. Using the military justice system, understanding these is the difference between the tactical victory and the strategic feature. Let's go into NJP. Standard of proof corresponding of the evidence, meaning more likely than not. More likely than not. Due process, streamlined and administrative. Speedy trial and immediate resolution. Constitutional rights and due process. The Sixth Amendment. This guarantees the right to a public, speedy and public trial. If you refuse the NJP, you're demanding the government prove its case from where the speedy trial clock begins, typically from 120 days. So about 5 to 6 months estimate in time. Due process and NJP due process is limited on the right to be notified. The right to see an evidence, the right to make a statement at court-martial. Due process includes the right to a military judge, a jury, and a cross-examination of the witnesses. The tactical risk. Where a court-martial has a much higher burden of proof beyond a reasonable doubt, it also covers the risk of a federal criminal conviction, impunity of discharge, bad conduct, discharge, dishonorable discharge, NJP cannot give you. Now the decision is, do you excuse or do you accept? If you accept an NJT, you're essentially saying, I will let my commanding officer decide the fate on the lower 51% standard to avoid permanent criminal record. If you refuse an NJP, you say, I do not believe the government can meet the 99% standard beyond a reasonable doubt, and I'm willing to risk a trial to prove it. Here's a crucial note: you cannot accept the NJP only. They will use the higher standard of proof. You accept the former NJP, you accept the corresponding with the evidence. Standard comes with that. Now, how do you interrogate this in evidence and process? This is the final part of the guide. Let's just say this over again. Educational purposes. Just standing there, I'm just simply analyzing this from a legal board. I'm not a lawyer. I do not have legal advice. You should exercise your right always to counsel with the defense counsel or JAG before your NJP hearing. Let's go to the discovery phase, asking for the evidence. Before you decide to accept or refuse an NJP, you have a right to see what command has on you to ensure to see what command has on you. Use these questions to provide the strength of the corresponding of the evidence, the 51% standard. Question to command size legal. May I respectfully request permission to review all the evidence that is enclosed on the list of the NJP notification. Intent. Ensure they aren't hard witness statements or physical evidence that might help you. If I may ask you to respectfully ask permission for, are there any statements that witnesses that are exemplary prove that I didn't do it? In other words, force this command to acknowledge evidence in your favor, not just against you. Now also, ask the specifics. Well, I'm respectfully requesting permission, sir, ma'am, what I prefer. That use of the uniforms on the military custom articles and element of defense and not being accused of allegedly. You cannot defend yourself unless you know exactly which part of the law is said you allegedly broke. Now you have to challenge the standard of proof after you know the NJP is the lowest standard in the trial. You want to ask questions that highlight the reasonable doubt in the room. Even if the CO needs only 51% certainty. Obviously, as I worded it before, sir, such ma'am. Does the evidence show a clear violation, or is this based on the assumption of intent? Another question you ask, are the conflicting witnesses' statements create a lack of clarity in the timeline? You can always put it like this too and understand some extra advice. You can always learn how to put a yes or no statement behind all this, saying, sorry ma'am, does this evidence show a violation of, or is this based upon an assumption or intent? Yes or no? Or are there conflicting witness statements that create a lack of clarity in the timeline. Is that correct? Was there an evidence gathered in accordance to Article 31 Bravo, rights, advisement? Would you be able to confirm that with evidence, please, and proof and putting in writing? Questions you can ask your defense counsel. If you're consulting with a lawyer before your NJP, these are your high-level questions that you ask and need to protect your career. Does the government's evidence need to be beyond a reasonable doubt standard required for a court-martial? This helps you decide if you should refuse NJP or accept it. If I refuse any non-judicial punishment, what are specific speedy trials, Romeo, Charlie, Mike, 707 timelines that command must follow? What is the maximum exposure at a special court-martial compared to the maximum punishment of this NJP? If I accept an NJP, how would this impact my pro and cons market negotiation promotion, or my re-enlistment codes, RE code for MC1, use a separate. Let's go into due process. If you feel like the process is being rushed, use these questions to your rights to a fair hearing. I would like to request a reasonable extension to counsel before making my decision. Is this granted, yes or no? Will I be able to call set witness name to provide a payment into my defense during my hearing? Can I submit a written manners of exoneration or mitigation for the records? Take away from this, you can never move until you understand your opponent's threat. In non-judicial punishment, the threat is the evidence. By you specifying the elements of the offense and full evidence package, you are affording in command to prove that they have 51% certainty. If they do not have proof it, then the evidence, or if the evidence is weak, you have a much stronger argument for dismissal or higher or a lighter punishment. Now study these elements for your specific charge in the Manual of Court Martials, MCM's Part 4. For example, if you're being charged with Article 92, failure to obey an order, a lawful order, the government must prove A, a lawful order existed, 2, that you knew of the order, number 3, you had the duty or the lawful authority that you must needed to follow it. If they cannot prove one of those three, the corresponding of the evidence fails. The checklist is this: before you walk into the commander's office, must sign it, accept or refuse block. You must ensure due process is bypassed. Use the structured checklist to make sure that you got the intelligence needed for winning defense. Okay. Under U.S. Code Section 10, 15, you are entitled to see the evidence against you. You just ask specific questions you aren't being applied to. The question may, sir, may I have a copy of the evidence under this type of enclosure. You need to see what exact charge or witness statements to find inconsistency, if thereof. Are there any Article 131 statements on file for the record? If you're interrogated without being read your life, the evidence may be legally poisoned or not admissible in court for a court-martial or even the entire proceeding. What are specific elements of the offense for my charges? Forces the legal officer to explain exactly what they think they can prove. Now, analyzing that standard of proof. When you're referring a hearing, you must shift the focus to what you think happened to what the evidence proves. Who cares about what quote-unquote happened? You must question the corresponding. Sir or ma'am, considering the conflict of witness statements XYZ closer to whatever, the evidence actually reaches the 51% more likely than not threshold, or is that too much uncertainty to proceed? Highlight the lack of evidence beyond the heresy in this statement. Is there any physical or digital logs, photos, records that place me at this scene? For examples and hypotheticals. Now let's play another. Okay, if you are considering NJG and going to court-martial, you must attach your counsel these questions as you see. As I say again. And then let's go with the matter of exoneration mitigation. Character. And being able to ask, may I be able to submit character statements or master brief sheets to the matters of mitigation? And can I provide evidence of my prior service to show that this individual is out of character? Like basically saying, I have evidence to show evidence. Now let us finish this video. The big three of the UCMJ breakdown. Let's go into three main articles. Article 86. AWOL, absent without leave. This is a strict liability offense, but the government must prove the specifics of your intent and location. The elements, what they must prove, that you failed to go to set appointed place of duty at time prescribed. Mistake of fact, did you receive conflicting orders or to be? As a question. Did you know that did you know of the appointed place and time? Did you know the what, the where, and the when? Lack of notice, was your duty roster posted properly, or did you or did you have access to it? That was your absence without authority. Saying authorization. Did the NCO or officer give you verbal permission to be elsewhere or in writing? Let's go into Article 92, failure to obey an order or regulation. This is the most flexible charge for a commander because it has strict consequences for knowledge. What they must prove, command: that a certain lawful general order or regulation was in effect. Legality: was the order constitutional within government authority to give? Did you have a duty to obey that order? Did the order actually apply to someone of your rank or mission, occupation, or specialty that you violated, or failure to obey that order? For non-general orders, the government must prove you actually knew about said order. Let's go into Article 134. General article: this is used for disorderly conduct or conduct superior standing to the good order and discipline. It is the hardest point because it is broad. What they must prove: that did you or fail to do a certain act. Axis legis: did this act actually happen, or is it based upon heresy? That your conduct was prejudicial to good order and discipline. Did your actions actually cause a disruption, or is command just unhappy, quote unquote? Did that conduct bring discredit upon the armed forces? Was this act private? If the public didn't see it, it's much harder to prove discredit. In chess, your opponent is missing a piece, you can't checkmate you. In law, your command is missing one single element, they cannot legally find you guilty. If you're the NJP and you can prove that you didn't know about Article 92, Element 3, then the entire charge should fall apart. Obviously, we went over Article 134, Article 86, and Article 92, failure to obey, unauthorized leave, Article 134, general argument. Now let's go into my legal philosophy. This analysis for educational philosophical purposes do not review the official views of the U.S. Marine Corps and the DoD, Department of Defense. This is not constantly legal advice. This is my quote for you, whoever is watching this. To navigate the storm of the law, one must map the currents, whatever bound by UCMJ, federal statute, local ordinances. Justice is not found in the science of the accused, but in the mastery of the rules. You cannot overcome a system you do not understand. You can only survive it through the precision of your knowledge. Also, let's go about jurisdiction breakdown. The board changes based upon where you are standing. Overcoming a legal challenge is requiring the rule book that is currently in play. The UCMJ is Title 10 of U.S. Section Code, good order and discipline, corresponding to the evidence and reasonable doubt. Federal law, U.S. Section Code, USC, crimes against the nation beyond a reasonable doubt. State law, state penal codes, crimes against the peace beyond a reasonable doubt. Company or local ordinances and bylaws, public safety and health, varies, often civil and fine based. Thank you, and I hope this guy's helped you out.